afternoon, ladies and gentlemen. Thank you so much for tuning into Chapman Law Group. This is another one of our video logs. Today with us is Aaron Kemp. He is the practice chair for our regulatory division that deals with all kinds of regulations, deals with licensing, peer review, credentialing, and National Practitioner Data Bank, which is an area that we're going to talk about today. Good afternoon, Aaron.
Good afternoon, Ron. It's a pleasure to talk to you today.
Thank you. Could you tell our audience a little bit about yourself, background?
Yep. Absolutely. I've been an attorney in Michigan for 22 years. I was educated at Michigan State University College of Law, graduated cum laude from that institution back in '97. Started working almost immediately in the field of healthcare law when I had not even passed the bar yet. Started work at a medical malpractice firm locally here in the Metro Detroit area. Was involved in defending physicians, particularly psychiatrists and chiropractors in medical malpractice cases. Found that had a great interest in that. Always have been interested in defending physicians who've been wrongfully accused of either malpractice or licensing issues. After that, I worked at a larger firm here in the Metro Detroit area for about 5 years, got some general business experience in a variety of practice areas, but then had the opportunity to return to that same malpractice firm years later and worked there on a number of different issues, compliance, licensing, malpractice, of course, saw both sides of malpractice, plaintiffs and defense, but always enjoyed the defense part a lot more than the plaintiff's work. And then from there, worked at a subrogation firm, handling some insurance issues for a while, but luckily was able to come here 5 years ago and have found my real passion for the law in licensing, regulatory affairs, and assisting physicians in either regaining their licensure, defending them from bad faith peer review, and helping them with National Practitioner Data Bank issues.
Now, you're the practice chair of our regulatory division. What does that really mean?
It means that I supervise 3 attorneys that currently work under me, 2 in Florida, 1 here in Michigan. We coordinate our efforts to defend our clients to the best of our abilities. We share different strategies, different ideas. I work with them in handling some of their bigger cases, strategy-wise. They assist me sometimes when I have a question regarding something that's going on in Florida. Particular where we have crossover regarding a data bank case that I'm handling here, having a licensure matter at the same time in Florida. So we work well together, and we have a very good team here at Chapman Law.
Now, issues regarding, let's say, National Practitioner Data Bank, those are nationwide, correct?
Yes, they are. We have clients all over the country. I currently have clients in a wide range of states: Texas, California, Arizona, a number here in Michigan, but that's federal law, so we can handle a case dealing with a data bank issue no matter where anyone's located.
And that's the same as well with peer review and credentialing. When we're dealing with hospitals, we represent clients all over the country in those issues as well.
Absolutely. We have a number of VA cases as well. The Veterans Administration has some particular matters of concern for practitioners nationwide. Their mission is to help veterans, but in the meantime, they have a tendency to abuse some of the practitioners who are trying to fulfill that mission, and we do our best to defend them when they've been wrongfully accused of not meeting those goals.
Excellent. Now let's talk about the National Practitioner Data Bank. I think it's widely misunderstood by a lot of people. First, it's a federal agency. What's its purpose?
The purpose was, it was originally conceived back in the mid-'80s, and this was a time where there was the alleged malpractice crisis. And what happened was there was a push by senators to have hospitals conduct peer review, but not be worried about the immunity for it. So there was an act passed in 1986 called the Healthcare Quality Improvement Act of 1986. And its original goal was to provide hospitals with incentives to police their own. There was widespread fears that doctors were moving from hospital to hospital without any consequences, and thus this was causing an explosion of malpractice cases. So as part of that incentive for hospitals to police themselves and providing this immunity, a national practitioner data bank was set up to enable hospitals, credentialing agencies, state licensure boards to be able to report physicians who had committed, in their eyes, wrongdoing for either issues related to their competence or their conduct. So they wanted to have this nationwide database that was not available to the public, but available to these credentialing agencies, hospitals, licensure bureaus, to provide them the tools they need to make sure that the physicians were doing what was required of them.
So let's sort of break this down into three areas. We want to talk about litigation, talk about state regulatory agencies, licensing agencies, that type of thing. And then let's talk about hospitals or employers that have peer review and credentialing. So with respect to civil litigation, so I have a medical malpractice case, maybe I lose it. What happens? Who has to be reported? How are they reported? What's the story with that?
If the money for the malpractice case is paid out of personal funds, then under the data bank, it's a non-reportable event. That does not happen regularly. Most of the time, the malpractice payment is made by the payor, whether that's the insurance carrier, the hospital. They then are required to report that to the data bank. Now, there are certainly cases, and we have one right now, where a practitioner was never identified in the complaint, never identified in the settlement agreement, but was still reported by the payor as responsible for a rather large malpractice settlement. And we're working to dispute that right now, because that does happen, where you have a case in which the complaints against the hospital, no one is personally identified, and a large settlement's paid, but still the physician's left on the hook for that. And it appears down the road, for purposes of other credentialing, for employment, that he was involved when, of course, he had no involvement at all in the payout, in identifying him in the complaint, or in the settlement agreement.
So we hear a lot when we're talking about civil litigation and National Practitioner Data Bank, an indemnity payment. Was there an indemnity payment made on behalf of a physician? Are you really referring to, does an insurance company or an employer or somebody pay a settlement or a judgment on your behalf that's considered an indemnity payment?
Yes, that's where that would be triggered, yes. And those are the cases where we work with physicians in those types of situations where that payment's been made, they've been personally identified in the complaint, to at least have their narrative portrayed. Because certainly in every case, there is an expert that was supportive of the physician, and there's a way to file what's called as a subject statement. It's fairly short, it's 4,000 characters. Which sounds like a lot, except they count both punctuation and the spaces, but that enables the physician to have his defense laid out for everyone that's ever seen the report for the past 3 years, and any future entities that were ever to pull that report. That's why it's very important to work with attorneys that have experience in this area like we do, to make sure that 4,000 characters is concise, but also you use the full breadth of it to make sure that everyone who sees that report understands this physician was not responsible for this payment. Most of the cases, the physician has very little say in having this payment paid out. They're at risk of being non-cooperative and having their insurance pulled if they don't agree to the settlement, and nobody wants to be bare at the end of a protracted litigation and have to pay out of personal funds. So many times they feel that it was unfair, they did not get a chance to defend the case, and that's where we can come in and assist them.
Now, in some of those cases, well, wait, before I ask that, we're only talking about medical malpractice cases. So
Yes.
If you're sued for breach of contract, the hospital sues you over a lease, it doesn't matter. It has to be a medical malpractice lawsuit, correct?
Yes, it has to deal with competency or conduct. It has to be malpractice in nature. Otherwise, it's a non-reportable event. And certainly there are many things that are not reportable to the data bank, such as administrative actions. If a physician were to lose privileges at a hospital for having his board certification lapse, for not having his records up to date. But in the context of civil litigation, it has to be a malpractice case.
And then when we're talking about the malpractice case, sometimes they'll dismiss the doctor, and then the hospital or the employer will pay the judgment or pay the settlement. Does the doctor still have to be reported under that scenario?
Does not, but occasionally there are things that fall through the cracks. There are arguments to be made that even though the doctor was, dismissed from the case, he was personally identified in the complaint, and we've had those cases as well where a malpractice payor has left them in and reported on their behalf, even though they've been dismissed from the case, and we've worked to try and dispute that.
Do you recommend that that's something that a physician or a nurse or any healthcare provider speak with the insurance carrier or speak with their attorney about whether they're going to get reported under what circumstances before maybe they agree to settle something?
Absolutely. That's why it's important in many cases to have personal counsel involved to protect their interests. While there are, certainly are attorneys that handle these types of cases, handle the defense of the malpractice suit, issues can arise where there's apparent conflicts of interest between the interests of the hospital and the physician individually, and that's why we certainly work with physicians to render personal counsel assistance in those circumstances to make sure that whatever dismissal happens, whatever happens in the case, we're there to speak for that physician.
Okay. Now let's switch gears and talk about some administrative procedures. So in that, I think I'd like to talk about licensing, what a licensing board might do, maybe an administrative procedure, like if CMS puts you on exclusionary list or they accuse you of filing a false claim, you have a civil monetary penalty, or maybe your registration's taken away by the DEA or something like that. What about those? What kinds of administrative things are reported?
Any action taken on a physician's license, any sanction, is a reportable event. Now, certainly there are states, unlike Michigan, Florida, there are a few states that have the availability of an administrative fine. An administrative fine does not need to be reported, but anything outside of that needs to be reported. The fines that are paid out in Michigan, Florida, most states are a reportable event. And anything beyond that, such as suspension, probation, reprimand, continuing education, those are all circumstances which trigger a report to the National Practitioner Data Bank. This didn't used to be the case several years ago, but most states have, in efforts to be compliant with Medicare and Medicaid, have come on board and now require reporting of all administrative actions that result in a sanction to the practitioner. And certainly CMS reports to the data bank, OIG reports to the data bank as well. Any exclusion is a reportable event.
What about if there's a complaint filed or an administrative action filed, you take it all the way to some sort of hearing and you win? But does that mean you won, so nothing's getting reported to the data bank?
Unless it's a sanction, it's a non-reportable event. If the practitioner is able to win, if we're able to take that case to a hearing and succeed, then the action is dismissed. It's taken off the practitioner's record, and it's as if it never occurred.
Now let's talk about what some would say the most damaging area, and that would be in peer reviews. First of all, most peer reviews, would you agree that, or at least a lot of them, they're basically political?
They are. Most of the ones that I've had experience with relate to issues of either an economic advantage being sought to be taken against a physician, push them out, and allow hospital employed physician to take that business, or it is political in nature. It's personalities that clash. It's this person doesn't get along and play well with others. We need to force them out and get somebody in here who can, play well in our little sandbox. It's very rare that you see legitimate peer review for what it was designed for, to enable physicians to improve their practices, to enable the hospital to comply with mandates from CMS, from other accrediting agencies. Most of the time, these things are taken for reasons other than a legitimate need to assess someone's conduct or their competency.
If the hospital or the agency you're employed with that does a peer review and they report you, do you have any cause of action against them? Can you sue them for anything if it was not a legitimate report, or is there immunity when you report to the data bank?
Federally, there is immunity if they are in compliance with the Healthcare Quality Improvement Act. Now, there are 4 things that are required to get that federal immunity. It has to be something that the hospital takes on reasonable belief that it's going to improve healthcare. They do a reasonable investigation. They offer adequate notice and an opportunity for a hearing, and then they believe that their actions are reasonably based on the facts. It's a very low bar to hit to get that immunity in federal court. State courts, such as Michigan, Florida, other entities, have their own state immunities for legitimate peer review. The bar for those is you have to prove, at least here in Michigan, you have to prove malice. You have to prove that the actions that were taken were either in ignorance of the truth or were in violation of what the truth was. Somebody willfully lied to the peer review panel in the course of that peer review. Again, that's a very high bar to reach.
Now, peer review is something, the details of that, we will talk in another video blog, you and I, about that whole process. But let's just talk about the reporting. What if during, and let me give you some scenarios, what if during an investigation, a peer review, you decide, well, I'll quit and I'll move on to another hospital? Do you avoid being reported then?
No, you do not. Unfortunately, any type of peer review is considered an ongoing investigation, and any healthcare practitioner, whether it's a physician, dentist, anybody that's undergoing peer review by an accrediting agency, hospital, if you remove yourself from that situation, if you attempt to resign, then that is still a reportable event. Now, there are certainly situations that we've had here where somebody has lost their hospital privileges as a result of a contract. The group they were employed with lost the contract, and as a result, there's a clause in the contract whereby their hospital privileges were terminated. Now, in those circumstances, that's a non-reportable event, but if there's an investigation going on while that occurs, that's a situation where we've had to get involved and negotiate with the hospital to make sure that's a non-reportable event, because the contract is what governed the termination of those privileges, not a professional review action. Most of the things that are reported to the data bank following peer review, they have to be the result of a professional review action whereby the credentialing is affected for longer than 30 days. Suspensions shorter than that, 29 days, those do not have to be reported. But once you hit the 30-day mark, any professional review action that affects their credentials for longer than 30 days has to be reported.
So let's talk about things like summary suspensions or, hey, doc, why don't you just take a vacation for a couple of weeks while we figure this out because we don't want you to practice in the hospital, whatever. What's the criteria for when those types of things? And is there such thing as an informal, well, we're not going to summarily suspend you, but don't come to work for a couple of weeks?
Investigations do not need to get reported. It only needs to be reported if there is a professional review action that affects the credentials for longer than 30 days. So a summary suspension that were to go longer than 30 days would need to be reported. If it were to be a leave of absence for longer than 30 days, that's the result of a professional review action, that's also a reportable event. So it's important for practitioners to be aware of what the rules are and to consult with qualified counsel to make sure, hey, I'm going to take leave. They've told me this is not a big deal. I can just come back whenever I want to come back. You want to make sure to hold the hospital's feet to the fire on that, get something in writing that would indicate that, but more importantly, review what the bylaws say, review what the contract says to enable that practitioner to make the proper choice so that it's a non-reportable event if that is indeed being offered.
Now, the hospital that the peer review committee was operating under, what requires them? Is there some standard that says they have to? Is this the law, or do they do it when they want to, when they don't want to? What's the criteria for that?
The criteria is the Code of Federal Regulations require them to report this as part of the National Practitioner Data Bank rules, all part of the Healthcare Quality Improvement Act of 1986. And everyone is aware of this on the hospital's end. They all use this as a stick against their practitioners, especially when they're offering, what's happened recently is they're offering lots of 29-day suspensions, But during this 29-day suspension, we need you to come up with a plan of corrective action on your own, a plan of either continuing education, or perhaps you plan to go to a program to deal with anger management. And if you don't provide us with that plan after 29 days, well, then we're going to report you because we're going to extend that suspension longer than that 29 days. So it's almost as if they're failing to provide them due process during that time period. And we've had to be involved with a few cases like that recently.
Now, you talked about the Quality Improvement Act. That act also sets out that the hospital, through peer review, has to have due process, meaning the doctor has to be able to have a fair hearing, right?
Yes, there's a requirement, and what the statute says is adequate notice and an opportunity to be heard. Now, most times you would think that that means compliance with the institution's own bylaws, but unfortunately, there's case law here, specifically in Michigan, that's held that even if a hospital violates its own bylaws, it still is entitled to the safe harbor provisions of the Healthcare Quality Improvement Act if they provide that adequate notice and an opportunity to be heard. So again, that's a very vague concept, what's adequate in the mind of the practitioner versus what's adequate in the mind of the hospital. But that's, again, why it's important to have counsel available to the practitioner as soon as possible to challenge the actions that are being taken by the facility. And again, anything that's occurring where you can dispute it, where you can say, this is a violation of due process, you've not provided adequate notice. The notice is not specific to provide the practitioner with the knowledge of what they have been alleged to have done wrong. You want to challenge the hospital, put them on notice that you are making them aware there's potential violations of the Healthcare Quality Improvement Act, and they could potentially be liable, and their immunity could fail if they don't do the right thing under the bylaws and under that act.
Now, when you are reported, is there a certain timetable or, I guess a timetable that a practitioner has to meet if they want to challenge?
There is no, there is no deadline for filing what's known as a dispute resolution. So what can happen is the institution will file the National Practitioner Data Bank report. They are required under the law to file that in 30 days. However, if they violate that time period, there's no penalty to the institution. So it's really not a hard and fast deadline, but it has to be reported within 30 days under the law. And then at that time period, the practitioner can instantly challenge it. They can allow 2 or 3 years to go by. But at a certain point, if they wish to dispute it, they need to send a letter to the reporting entity challenging what the basis of the action was, meaning that there are only 2 ways you can challenge a data bank report. Either it should not have been reported in the first place, it's not a component of the Healthcare Quality Improvement Act, it's something that was either an administrative action, it was a medical malpractice payment that was paid out of personal funds, it's a non-reporting event. That's one way you can challenge it. The only other way you can challenge it is to indicate that the facts that are laid out in their report are inaccurate. Other than that, you're not permitted to challenge the due process of what occurred either on the licensing side, the peer review side. All of those challenges will be rejected by the National Practitioner Data Bank. But once you send that letter to the reporting entity, 60 days has to elapse to allow them to respond to that letter. After that 60 days has elapsed, you provide a copy of the letter and you move the report into what's known as dispute resolution, meaning that it will then be reviewed by the director of the National Practitioner Data Bank to determine whether it was a reportable event in the first place or if it was factually inaccurate.
And who is the final arbiter of whether the report was properly filed or not properly filed? Is it the hospital that filed it, or is it the National Practitioner Data Bank director?
Under dispute resolution, it would be the director of the data bank. And if the practitioner disagrees with that determination, there's one final review, which is reconsideration by the Secretary of Health and Human Services office. There's no time limit for that as well. So at any time you can challenge this in a final appeal level for reconsideration, but most of the time they're looking for something that was not properly considered by the data bank on the initial review or new information that's come to light as a reason to overturn that decision.
So I guess one of the last final questions that I have is you're reported, You've challenged it, but your challenge wasn't successful. How long does this information stay on the databank so that the public or other agencies that are going through the credentialing process, you move to another hospital, another practice, how long is it out there for people to see?
It's out there forever, and that's the part of this that's really unfortunate, and that's why practitioners come to us all the time with concerns about the economic impact these reports are going to have on them, not only from an occupation standpoint, from an insurance standpoint. They find it very difficult to get liability coverage. In addition, it can impact their professional board certification, which again can impact whether they're going to be credentialed by a hospital. So there's a lot that goes into this that we attempt to help physicians and other practitioners with, and we have a very good track record of doing the best we can to make a very bad situation much better for those individuals.
I guess I have one other question too. You mentioned board certifications. So if I'm certified by, the American Medical or the American whatever, family practice or something, and I'm board certified in family practice, internal medicine, emergency medicine, whatever. If for some reason the board revokes my certification, does that get reported?
As long as it's not an administrative action. If it's something related to conduct or competence, then that's a reportable event. And that, again, can impact the employability of that individual for a very long time.
What about if, every 10 years now, the grandfather clauses for a lot of physicians have pretty much lapsed. So the new physicians, every 10 years, they have to recertify. What if they just fail to pass the recertification? That's not reportable, is it?
That is not a reportable event.
Okay.
No. We're talking about matters of having the board certification terminated because of a healthcare fraud conviction, because of a licensing suspension, because of something which may in fact trigger its own national reporting data bank entry itself. But loss of board certification for that would be reportable, but not for something related to failing to complete their MOCs.
I have seen cases before where board certified physicians have given testimony, sometimes more than one time, that the prevailing board takes exception with and believes that their testimony was false, inaccurate, misleading, et cetera, and they revoke their certification. That kind of event would be reported. That's
a reportable event. That's related to their competency, yes.
Okay. Any last words you would like to say to our viewing audience with respect to National Practitioner Data Bank? And I promise you we'll have Erin back to talk about peer review and credentialing, which could take up a whole segment or more on their own.
I would just encourage any practitioner that believes that they have been the victim of bad faith peer review, that they've been a victim of a wrongful licensing entry, that there's a medical malpractice case that went awry and they've suffered a data bank entry, to reach out to us, and we will do everything we can to make this situation better for them, to improve things, to improve their quality of life, improve their employability, improve everything that needs to be improved. Because to allow that data bank entry to just sit there unresponded to, without a subject statement, without dispute resolution, can have a very damaging impact on their careers.
Well, thank you very much, Erin, and thank you so much for tuning in again. National Practitioner Data Bank is a good thing in some circumstances. It can be a very cruel tool used by people in bad circumstances, but it always has an effect on the licensee. It's harder to get employment, harder to get insurance. Good hospitals, teaching hospitals, oftentimes won't touch you if you have a report. And we're here to help you. As you know, Chapman Law Group is a professional healthcare organization. That's all that we do. We have 17 attorneys that are all specialized in various areas of healthcare, Erin being one of them, leading our regulatory division. And thank you so much. I'm Ron Chapman, and look forward to talking to you again.